Well, welcome to the third class. We're going to be going over provisional patents in this class. First thing is that there's an easy and a hard way to do provisional patents right. If you look at the next screen on your handout, you'll see the easy way. The first thing is that you file the provisional before you disclose the invention. Number two, the provisional is written well enough to later on support a utility patent that claims priority back to the provisional. And number three, you file the utility within a year of the filing date of the provisional. If you remember those three things, you've pretty much got it made. But provisionals, unfortunately, are perhaps the most popular and also the most misused type of intellectual property out there. So we're going to be going over them in some detail in this class. So in a perfect world, you file the provisional as soon as you're patent pending. You've got your foot in the door at the U.S. Patent and Trademark Office stating that you're the first person to file a patent application on this idea. You go out and you use that next year to maybe seek investors, do some more R&D and perfect the invention, do some focus groups, see if people are interested in it. Heck, you can even try to sell the invention outright. And then at the end of the year, you file a utility patent that effectively claims priority back to the provisional. That will give the utility patent the filing date of the provisional, which means that if anything happened during that year, such as a competitor stealing your idea and filing their own utility patent application on your invention, well, you've got them beat because your utility reaches back and takes the date of the provisional as its filing date. Then after you get your utility patent filed, it magically gets examined quickly by the U.S. Patent and Trademark Office. You end up manufacturing products and selling it, and eventually you either retire off your business or you sell your business for a lot of money. So in a perfect world, that is what happens. You don't have to worry about anything else. But real life is much different. We're going to be going over a few examples of real life in the next few slides. Okay, so let's start off by talking about how you do it right. You file your provisional application, and the provisional application is written well enough so it later supports a utility patent application that's filed within a year. You see in the example here, you've got your provisional filing date, and your utility patent will take that provisional filing date as its filing date because the provisional was well written and the utility application was filed within a year of the provisional filing date. Now, if this is a situation where your utility patent filing date is actually going to be able to effectively reach back and grab the provisional filing date, you don't need to worry about disclosing your invention after you file the provisional. Now, what is a disclosure? Well, disclosure can be showing it in public, having it at a booth in a trade show, selling some on eBay, making a YouTube video about it, under certain circumstances even showing your invention to a group of potential investors or other people who aren't under a non-disclosure agreement or other device such as that that's going to prevent your disclosure from becoming a disclosure that can be later on used against the patent application you file. So basically you get the provisional filed, go ahead, shop it around, try to see what the interest level is, and then you file the utility within a year of the provisional. Okay, let's go over some typical situations that end up putting the inventor in a very bad position. So the first one we're going to call the cheap inventor. So this inventor didn't want to spend money on a provisional, took the invention to a trade show, showed it off to a bunch of people. And there really wasn't much interest in the trade show, so the inventor didn't think much about it. Then a few years later, the inventor gets a phone call from somebody who's interested in the invention. Now, the inventor can go ahead and prepare a provisional. It can be the best provisional in the world. Then later on, within a year, they can prepare a utility patent application. The utility patent application, again, best utility patent application in the world, cost them $250,000 to have it prepared and filed. And the utility patent application effectively claims the date of the provisional as the filing date. The problem here is that more than a year has elapsed from the inventor's first disclosure. So even though you've got the best provisional in the world and the best utility patent application in the world, even if the utility patent application gets granted, anyone can challenge the validity of that patent by going back to the invention show that happened 5 years before the filing date and say, hey, you publicly disclosed your invention at this trade show, and I happen to have a picture from next year's trade show, on the front cover, there's you holding up your product. And the date is 5 years before your patent application filed. And under 35 USC 102, you have 1 year from your first public disclosure to get a patent application filed on invention. So you can spend a whole lot of money getting a patent, a provisional patent application, and then a utility patent application. You can successfully prosecute the utility patent application. But because more than a year elapsed from your public disclosure to the date of your provisional, you can have your patent invalidated later on. The end result of this is what I call inventional suicide. You can spend all sorts of money, but what you've got at the end of it is fatally flawed, and those flaws can be discovered fairly easily by somebody the first time you go around and you start threatening somebody with patent infringement. Okay, let's go over a second typical scenario whereby the inventor really ends up creating a disaster and they aren't aware of this until it's too late. So in this particular case, the inventor decided to disclose the invention before filing the provisional. So, okay, you've got a year from when you disclose your invention to get an application filed. It seems like no big deal. So a month or so after the disclosure, maybe at a trade show, the inventor has a provisional drafted. But let's say that the inventor uses elcheapoprovisionalpatents.com on the internet, where for 99 bucks you can get a provisional application prepared and filed, and you get a 6-pack of beer along with it and a set of the Ginsu knives or something like that. Anyway, the provisional is garbage, but the inventor doesn't realize the provisional is garbage. So within a year of the filing date of the provisional, the inventor has a utility patent drafted, and the utility patent may be a super well-drafted utility patent, but when the USPTO examiner looks at the utility patent application and sees that it claims priority to a provisional, the examiner is going to look at the provisional and make sure that the provisional supports the utility patent application. And in this case, the examiner is going to look at this one-page piece of junk that the inventor had prepared for a provisional application. The examiner is going to say, hey, this provisional, this thing should be at the bottom of a bird cage or shredded up for cat litter because it's worthless. So I'm going to deny you the earlier filing date. Now the inventor has a huge problem, because if you look at the date of the utility patent application, it's more than a year after the public disclosure of the inventor's own application. So at this point, the inventor has shot himself or herself in the foot, because more than a year has elapsed between the date of disclosure and the filing date of the utility patent application. So here, by having a lousy provisional application, you end up, if you disclose before that, you're really under a very strict timeline to get that utility patent filed within a year of the disclosure, not a year of the provisional. And yeah, I run into this all the time with inventors who say, well, I don't want to spend a lot of money on the provisional, so I'm just going to do it myself. And they turn it in, and then they come to the patent attorney and they say, can you write a utility patent application? And a good portion of the time you look at the provisionals and you just say, well, I can write a utility patent application, but this thing is so poorly done, I don't think I'm going to be able to effectively claim priority back to it. I sure hope you didn't disclose your invention before you came into my office. And this happens all the time. And it's a very unfortunate situation, because oftentimes there's nothing you can do. You can't go back in time and get the inventor to either prepare a better provisional or not to disclose the invention before the provisional date. You just, if we could time travel, I do it all the time, but you can't do it and save these guys, and they're basically sunk at this point. You better hope that they can either make some tweaks to their invention such that you can file on an invention that wasn't disclosed, or you maybe go for a design patent or something like that. But the inventor, by preparing a lousy provisional, has really shot himself or herself in the foot. Again, inventional suicide, because you can pay a lot of money for that utility patent application, and even if it issues, it's fatally flawed. How does this relate to the Patent Reform Act? Well, before the Patent Reform Act, we were a first to invent jurisdiction, which meant that if you invented something and somebody else invented the same product, but you were able to prove that you had invented it first, you would have a chance to go and have the patent awarded to you rather than the person who may have filed earlier but invented second. So basically, first to invent was more important than first to file. Well, we are now changed, and we're now a first to file jurisdiction, which along pretty much is in accordance with the rest of the world, or at least the major patent offices. They all use first to file because when you go off first to invent, you're basically dealing with people stating when they invented an invention. And you can fudge a laboratory notebook, you can put on your Google Calendar that you had meetings when you didn't have them. And I think it was rather frustrating for people or the Federal Circuit anyway, to have to figure out who's really lying and who's telling the truth. So they took the easy way out, which is, it doesn't matter when you invented it, all that matters is when you're first to file. So where this comes back and hurts inventors is, let's say we go back to the do-it-yourselfer, and the do-it-yourselfer prepared a lousy provisional application, shows the idea at a trade show, and somebody else comes up with their own patent application after seeing this product at the trade show. And then even if the first inventor comes up with a utility patent within a year of the provisional, the USPTO examiner can deny that priority date again because the provisional doesn't support the utility. And at that point, then your competitor has won the race to the patent office because they've got an earlier filing date than you do. Now, there are things you can do. If you happen to have a cell phone or a movie camera taking pictures of your booth and the competitor walks up and says, "Oh my goodness, this is the best invention I've ever seen. I sure wish I was smart enough to think up something like that." And 3 months later, that competitor has their own patent application on your invention, and they've signed an oath in which they declare under penalty of perjury that they're the first and true inventor. Okay, that's a pretty good case to show that they were using fraud in filling out their oath. But how many people are going to have movie cameras recording every conversation at their trade show booth, and how many competitors are going to be stupid enough to see a good idea and admit right there that it's not theirs? So anyway, this is another way where you really want to have a good provisional prepared, because otherwise you may not get that as a priority date. So again, let's summarize what we learned about provisionals. File the provisional before you disclose. Have the provisional be written well enough so it later supports the utility patent application. Be sure to file that utility patent application within a year of the provisional filing date and effectively claim priority back to the provisional. Thanks for watching. I hope you enjoyed it.